this first edition of our AI Tech and Policy Talks of this year. For those of you who are not familiar with our AI TPT series, the idea and the goal is basically to offer an informal forum for discussing and somehow interacting on some cutting-edge AI tech and policy issues, and to create a digital place for interacting debates about these issues. And today, it's a great pleasure for me to welcome Dr. Marie-Hélène Peter-Spiess, who is a postdoctoral research fellow at the Faculty of Law of the University of Zurich. She's also a member of the URPP, Human Reproduction Reloaded research team at the University of Zurich. And she will be our speaker today for this session of AITPT on a topic that we have not discussed and discovered in any previous sessions of our AI Tech and Policy Talks. And the topic will be FemTech apps and AI regulatory challenges. And as we have done systematically in all our previous sessions, the sessions are structured in a way that the presentation will be followed by comments made by two distinguished experts. And today our experts are Professor Aurelia Tamò-Larrieux, who is our neighbor, basically, here in Switzerland at the Faculty of Law of the University of Lausanne. And the second commentator will be Dr. Anna von Kolfschooten, who is a lecturer at the Faculty of Law of the University of Amsterdam. So welcome to all our speakers and commentators. And as the essence, as mentioned earlier, is really to engage in the discussion. Everyone is most welcome to join in the discussion, either by using the chat or even better, by taking the floor after the presentation and the comments. Please note, as you will have seen, that the session is recorded, and the plan is for us to make it available online on the website of the Digital Law Center, along with the presentation that will be presented to you in a few seconds by Marie-Hélène Peter-Spiess. And as a courtesy, final point in terms of logistics, as a courtesy to our panelists and speaker, I would invite all of you, if that's feasible, to please turn your camera on so that we can also engage in perhaps more stimulating and pleasant interaction. So this, and without further ado, I now give the floor to Marie-Hélène Peter-Spiess for the presentation. Thank you very much.
Good afternoon. Thank you so much. So let me just share my slides. Can you see them?
Yes.
Okay, perfect. So thank you so much again for the invitation. As you know, I will talk to you today about FemTech apps and AI regulatory challenges. My presentation is notably based on an article currently in review, co-authored with my colleague Dylan Hoffman from the University of Neuchâtel, and otherwise my work on the topic is still ongoing, so I'm already looking forward to the feedback from our two commentators today, and of course from the audience. So before we dive into the topic, a quick overview of my presentation. I will start with a short introduction about the notion of FemTech and FemTech apps, their potential and risks. This will be followed by some considerations about the relevant legal framework. I will focus on the case of Switzerland here. Then I'll focus on the specific topic of AI regulation, what applies or could apply here, and finally, I'll talk about some selected challenges and perspectives. So as an introduction, I would like to briefly talk about the notion of FemTech and the related applications, as well as about the potential and risks of these technologies. Basically, the term FemTech is short for female technology. In other words, FemTech can be described as technologies tailored to the health of those with female reproductive organs. The term was first coined in 2016 by Ida Tin, a Danish entrepreneur who co-founded the fertility tracking app Clue. And the notion is actually quite broad, as it encompasses a wide range of areas and products, from merely physical devices to digital ones. So you can see here some examples of different subfields of FemTech. So now focusing on FemTech apps and AI, one example of a FemTech solution is health tracking technologies, specifically marketed at women, which have surged in past years. So here I mention women to reflect the wording mostly used, but many users of these technologies may not identify as such. And so this surge is due to various factors, notably rapid progress in AI technology and digitalization, but also societal shifts that bring more attention to women's health needs, and unprecedented events as well, such as the COVID-19 pandemic. And so today we're going to focus on a specific case of such solutions whose popularity has been growing, and that is fertility tracking applications or apps, also called menstruation apps or reproductive health apps. As you can imagine, these apps can serve menstrual cycle monitoring, conception, but also contraception, among others. So I take it that you all know how these work, but very briefly, usually users enter some parameters such as menstrual cycle information and fertility signs. This data is used to predict fertility windows and make other recommendations. And so here you can see some additional examples of how these look like. What you can bear in mind is that many of these apps rely on AI to make predictions. And one more precision here, these apps are used as a case study, but naturally some considerations can also apply to other mobile health apps. However, fertility tracking apps are different for a number of reasons, including the range of users, the data handled, which is highly sensitive, but also the fact that unlike, for instance, a cardiovascular app, which usually relies on objective measurable data, such as the heart rate, these apps focus mostly on fertility signs, which can vary more and are also more subjective, except for temperature, but I chose to focus on standalone apps here. So that means those that are not connected to physical devices. So very briefly, this topic is especially important given the significant potential of these technologies. They have been praised for their potential to empower individuals and give them more control over their reproductive health. But there's also an important and often overlooked public health potential here. I will not go too much into the details, but basically these apps can assist not only in reproductive health, but also other issues such as management of premenstrual syndrome or contributing to addressing the gap in women's health research via the data collected. However, there are also important risks linked to these technologies. One major problem is accuracy, which has been described as a double accuracy issue. The apps themselves can pose reliability issues. And as mentioned, they usually rely on self-reported data, which can be imprecise, and statistical averages, such as a 28-day-long menstrual cycle, which may not reflect individual variations. And the problem is that these accuracy issues can lead to contraceptive failure and unintended pregnancies, posing serious health and psychological risks, among others. Then data privacy and security is another significant concern. Abuses may occur, for instance, via commercialization of data, but also, especially in certain jurisdictions, via surveillance and control. And finally, other issues include a potential for discrimination, but also tracking fatigue, among others. And so in a sense, a sort of paradox of control emerges. These apps aim to empower users by helping them gain control over their health, but they may also lead to loss of autonomy, for instance, due to data exploitation by third parties. So now that you know more about the technology, let me talk to you about the applicable legal framework, a true regulatory maze to be navigated. In general, the FemTech sector has been described as yet to be properly regulated. The UK rules on fertility-related FemTech have even been described as a complete regulatory failure. Why is that? Basically, it's argued that even when regulations exist, they are mostly not tailored to address the challenges specific to fertility-related FemTech. And on top of that, existing regulations are often highly fragmented. So what does that mean? A single tool is typically governed by multiple areas of law. Here is an illustration of some different legal areas that can be relevant to fertility tracking apps. And so you can see that the different legal fields that can potentially apply or influence use include medical devices regulation, data protection law, consumer protection law, and possibly AI regulation, among others. And so these fragmented frameworks can create various difficulties and risks. In practice, challenges include regulatory gaps, non-compliant practices, lack of enforcement, but also limited research and guidelines on safe use. And finally, in the Swiss case, another difficulty to be mentioned is that different agencies are entrusted with varying competencies and oversight. In this respect, in addition to our Swiss federalist system, which adds, of course, a layer of complexity. So as an illustration regarding the Swiss legal framework, one of the fields that can apply to these apps is Swiss medical devices regulation, which mirrors EU medical devices regulation and also to some extent refers to it. I'm going to briefly explain how it applies to these apps here, and you will also see later why this is relevant also in the context of AI law. So in practice, software, including apps, can be qualified as a medical device if certain conditions are met, and these include the app serving a medical purpose. And so to determine whether an app serves a medical purpose, reference is primarily made to the intended purpose of the app specified by the manufacturer. And so this means that the manufacturer is in practice to a large extent responsible for this potential qualification. Then as a result of being qualified as a medical device, these apps are classified into different categories with varying requirements depending on their risk level, such as mandatory certification and conformity assessment by a third party before they can be marketed. And so here again, it is the responsibility of the manufacturer to correctly classify the devices. So as mentioned, this leaves significant control in the hands of the manufacturers, even though this was nuanced a bit by the applicable case law. And so this is an excerpt from Swissmedic's website, the Swiss Agency for Therapeutic Products, which is the federal surveillance authority for medical devices. And so here is a translation. It is the manufacturer that decides if an app qualifies as a medical device. So as an example, if a manufacturer presents an app solely as being a period calendar, it could potentially avoid being qualified as a medical device altogether, to simplify. So recently, the Swiss Federal Administrative Court adopted a broad and relatively stringent approach to the classification of fertility tracking apps as medical devices. The court held, by reference to EU rules and guidance applicable at the time, that software applications designed to prevent pregnancy or facilitate conception are Class 2B medical devices. This provided a welcome clarification around the classification of these apps, since EU guidance on classification is not binding for Switzerland, although usually followed. And so basically you can see in this excerpt from an older judgment, the court really views contraception and conception as being of the same kind, representing, so to say, two sides of the same coin. And so it does not really differentiate so much between the two for classification purposes. However, what's interesting is that, by contrast, EU and Swiss rules and guidance in this field still classify contraception and fertility control or conception apps differently. So basically, for apps for contraception are class 2B medical devices, whereas apps for conception or fertility control can be categorized as class 1 devices. So that means with much lighter regulatory requirements. And so here, of course, it could be asked whether this distinction is justified or if this is an inconsistency, because a user can easily use a conception app and rely on the given fertility windows for contraceptive purposes. So as an illustration, here is a picture from the Swiss App Store showing the Clue period tracker and calendar app. So this app is described as an app for fertility and ovulation calculation, but as you can see here, it also carries a disclaimer stating that Clue should not be used as a contraceptive. However, in practice, how are we really sure that the user will not rely on it for contraceptive purposes? And so in a sense, in addition to inconsistent guidance in practice, this system really largely relies on the industry's goodwill and knowledge of the applicable regulations, and also on efficient monitoring and enforcement mechanisms. However, on this last point, you will see here that with regards to oversight and enforcement, we are, so to say, not there yet. Swissmedic has described the current medical devices apps landscape as an indescribable jungle because of shortcomings in compliance with medical devices standards, coupled with insufficient enforcement. In addition to that, Swissmedic primarily acts in response to public reports, which are rare. And it also mentioned that many manufacturers are simply unaware that their solutions might qualify as medical devices. So you can see there could be some improvement here. So now that you had a good illustration of some regulatory challenges linked to the medical devices regulation, we're going to focus on AI regulation in the field, and that may be relevant for those apps that include AI systems. And so you will also see why the two, so AI law and medical devices regulation, are actually intertwined. So first, to start, some reminders regarding the Swiss legal framework here. As you probably all know, Switzerland has remained largely passive when it comes to regulating AI, and there is to date no overarching AI-specific legislation on this topic. Last month, the Swiss Federal Council announced its AI regulation strategy, which was following numerous calls to regulate AI in Switzerland for a long time. And so basically, the Swiss strategy entails the following elements. Switzerland intends to ratify the Council of Europe's Convention on AI and to make necessary amendments to Swiss law. However, the goal is to adopt mostly a sectorial approach. So where legislative changes are needed, they must be as sector-specific as possible. And so finally, the plan in this context is also to develop non-legally binding measures to help implement the convention. So essentially, a bill is to be drafted by the end of 2026. And in all that, safeguarding fundamental rights has been described as one of the objectives of the regulation. What's interesting, though, is that the Federal Council only mentions the example of economic freedom in its press release when writing about fundamental rights. So you can see already that attention is being paid to industry players. But it remains to be seen, of course, how the concrete implementation will look like, and also how this might impact fertility tracking apps. So independent of these Swiss considerations, and most importantly, the recently enacted EU AI Act must be mentioned. This legally binding instrument came into force last August, and the act will be gradually applied within the next months and years. Why am I mentioning that? Because the Act has a broad scope, as it notably applies when AI systems are put into service or placed on the EU market, or when their output is used in the EU. And so this means that it can easily apply to Swiss providers or deployers, for instance. And so similarly to medical devices regulation, the EU AI Act classifies AI systems in various risk categories, and unacceptable risks are prohibited. Depending on the risk category, varying requirements apply, including transparency obligations, human oversight, stringent data governance, and management requirements. So now what's really interesting is the interplay between medical devices law and the EU AI Act. Despite the horizontal nature of the AI Act, connections are made with medical devices regulation. Under the new rules, AI medical devices that are required to undergo a third-party conformity assessment by the EU medical devices regulation are considered high-risk system. So concretely, it means that AI medical devices of risk class 2A or higher are considered high-risk AI systems and are thus subject to stringent requirements. But conversely, it also means that AI medical devices of risk class 1 and health-related AI systems not considered as medical devices are potentially only subject to certain requirements. So for instance, transparency obligations or AI literacy with no comprehensive oversight and accountability mechanisms. So what is the consequence of that? Basically, the oversight of AI medical devices largely depends on manufacturer medical device classification. Scholars have criticized that, saying that the issue of the intended purpose, which I mentioned before, is thus renewed in importance, and that this risk classification interplay again leaves manufacturers with considerable discretion over the requirements to which the solution is subject. And so coming back to our fertility tracking apps, concretely, whether an app is described as being for contraception or conception can have an important impact on possible AI-related requirements. And so this means that apps for contraception would in principle be considered high-risk AI, while apps for conception only could potentially escape the heavy requirements of this risk class. And so we really go back to the question around the relevance of this distinction. And so as a wrap-up, I'll now go over some challenges and future perspectives in the field. First, some key regulatory challenges. So as I already said, the criterion of the intended purpose is a tricky one, and the shortcomings of it are really reinforced by the new interplay created between medical devices regulation and AI regulation. Linked to this point is the inconsistent distinction I mentioned around fertility tracking apps, differentiating between conception and contraception. And related to that is also, of course, the issue of a possibly rapid change of use in case of AI evolving with time. So what happens in this case? Should a post-market adaptation of the designated purpose be explored? Another challenge I briefly touched upon is the issue of market surveillance, whether pre-market surveillance or broader post-market surveillance for all of these apps should be explored is an open question. And finally, among many other challenges, of course, the fundamental rights of all of these apps users, which represent a special category of users, should not be forgotten, especially regarding certain issues such as data protection. And so finally, looking at future perspectives, on a positive note, further guidance and information is awaited regarding both implementation of the EU AI Act and also regarding the upcoming Swiss AI regulation. And despite the challenges mentioned, the AI regulation, and especially the new requirements under the EU AI Act, can be welcomed as they provide additional requirements aiming at ensuring the safe and ethical use of these technologies. And so in all that, we should also not forget about the important potential of fertility tracking apps, especially if they are used within the right frameworks. So it really raises the following question: how can regulatory frameworks be designed to adequately protect all users, but also while enabling these fertility tracking apps to reach their full potential? So this is, of course, a very tricky question. And in the meantime, we should not forget about measures that are always easy to implement. And that includes, of course, awareness and education, both in the field of fertility, but also and especially in the field of AI, its risks and how to mitigate these. So thank you very much for your attention, and I look forward to the comments and the discussion.
Thank you very much, Marie-Hélène, for this very stimulating presentation. A lot of topics and issues, and also interesting to see to what extent we should or should not rely on basically the subjective intention of the stakeholders, the manufacturers, which as someone who is not necessarily very versed and very expert in medical device regulation, I think it's quite interesting to observe what you can expect from the market and what you should not, basically, and to find the balance as you were pointing to. But now time for our commentators to share their own view and perhaps questions with our audience. And first to you, Aurelia, Tamò-Larrieux, for your comments on Marie-Hélène Peter-Spiess' presentation.
Yeah. Thank you very much, Jacques. And I actually want to point out to just the last point that you made on education, because I think it's so interesting also, Marie-Hélène, that you end with this. I would challenge you, though, on the notion that this is maybe the easiest point to include, because I think this is actually already also a challenge, right? Like on how kind of to educate not only users, but also the market, as Jacques just mentioned. And this is a very interesting perspective. And I think this talk really fits well also within that topic of raising that awareness. So thank you very much for this very interesting presentation, and also for sharing your article with us. So we had a preview already of what is coming out. That's very nice. And thank you for the Digital Law Center also to invite me and raise this important discussion. I wanted to pick up on one point that you made especially, so this question of the paradox of control, and maybe offer two additional thoughts to that. I really liked that point that you made. And then maybe afterwards we can move the discussion, because I know Hannah also is going to talk about the AI Act on maybe the EU regulatory landscape, since you already mentioned very well and in great detail the Swiss regulatory landscape on this issue. But let me start with this paradox of control that I really like this point a lot. And I'm new, I guess, to the FemTech topic. Of course, we see strong parallels with the quantified self movement. I guess this is like a sub-dimension of it. So it's interesting, right, to see like in research these different parallels between a movement that has been kind of described quite a lot in the literature, and then kind of this more niche subject of FemTech. And here the focus is much more on this biological, gender-specific technology, as you show, that really records even much more intimate data than other kind of Fitbit devices that everyone knows would collect, right? So what is also interesting here is that the female body, especially reproductive organs, have always been objectified. Like, it seems a bit history that seems to reproduce a bit itself. But here, and I put this under like quotation marks, like so to speak, like fictional, right? But here the goal is this empowering twist. So that we can actually take back control over our own bodies and understand it and avoid unwanted pregnancy, as you show kind of with these different devices that you show. I think you had Flow and Clue that you mentioned, right? And I think there are a bit two layers of concerns here as well. So the one, of course, is that we invite corporations into these relationships, right? Someone has to process, share, understand, analyze that data for us. And this is kind of data that, you would potentially share with your partner, loved ones, but maybe not even. So it's a very kind of intimate of data set that you get here. And that this is a bit the second layer on top of it, as I see it, right, is that it's always put in this larger societal legal context, which can also quickly change. And I think the most kind of obvious example to take is the overturning of Roe versus Wade in the US by the US Supreme Court, kind of shifting back the power of abortion law to the states with a lot of strict anti-abortion measures that followed, right, in the US. So now imagine you're a user, like a person with a female reproductive organ tracking your cycle, and all of a sudden you get this fear, right, that law enforcement agencies potentially get access to it, or that this data is being shared, leaked with other authorities, or even people you just don't want that data shared with, frankly. And I think here this topic of chilling effect comes in, that has been researched in the literature, but maybe not to the extent that some researchers wish we would understand that concept. But by inviting this intermediary, this private company, we create this potential risk, right, for chilling effects. And so it's kind of very far away from this empowering twist, right, that we wanted to see. And this is, I think, why within the landscape that you showed us, right, with the different laws, this focus on security and privacy is so deeply important, especially within this subject of FemTech, where, like local data storage can be key, end-to-end encryption, understanding exactly how data is being shared or just forbidding the sharing of this data. All these aspects become very central here. And I say this because of another topic that for me is linked to this overarching theme of paradox of control that you mentioned, because a lot of these technologies, right, are tools not only to track menstrual cycle, but often also related to pregnancy tracking, baby monitoring, and much more, right? Like we get very fast, like for me, there's kind of this kind of blurry boundary between strictly femtech to tech that is much more also about parenting related issues, from, tracking your unborn, your infants, your children. It continues with checking on bottle feeds, diaper rashes, etc., like from the whole spectrum, right? And so this moves us to another territory, the one of interdependent privacy. And the questions really of, okay, but what data are we tracking? Is it strictly about one person? Is it about others? Is it about an unborn, an infant, children, your partner, etc.? And also raising this question of where this individual rights paradigm that we have, whether this works for these interdependent individuals, right, or that are being tracked as well. And so again, this is not necessarily new. I think we had this discussion a lot when we think of parent tech or sharenting, etc. Like under these headings, we had these enough. But I think femtech maybe intensified because of the intimacy and the pervasiveness of that technology, those discussions. And so this can kind of put us back to this maybe broader regulatory landscape. And I liked the slides that you had also with kind of the overview, right, of different regulations that you see here. I'm also skeptical that one single regulation could fix it all. So I would be very curious when you mentioned the UK rules, what happened there, or what was tried and why it failed. So if afterwards you could elaborate on this would be great. Because again, like it's going to be very hard to capture everything, right? And especially when you take this societal changing landscape also into account. But I think there are things that we already know especially when we think of privacy law. We know, and this brings it also back to education, right? We know that people are not reading unreadable information about a specific product, but we also know there are good ways to make this easier, from visual privacy labels to tailored interfaces. And we now even have the tools, and our own research shows that too, right? To actually create, basically on top of existing infrastructure, better, more visual, more personalized educational means for the users. Of course, it would help if regulators and data protection authorities would also pick this up and make it scale up a bit more quickly. And aside from that, so aside from the things we know and we could do, there are also other regulations emerging. I know Hannah again is going to be talking about the AI Act, but there are other tools in the EU. For instance, there's also the Data Act, which will take effect in September. And also here, the goal is on more transparency, but also more access to data by user or trusted intermediaries. And the focus again more on access and data portability. And I know, I mean, we all do, right, from also the GDPR and data protection law more generally, that there are mixed results with respect to data access and interoperability rules, but it's still, I think, still important steps that go into the right direction. So I guess also here to kind of mirror Marie-Hélène's more hopeful points at the end, I think I'm also remaining hopeful that we have different tools and different regulatory means to address some of the challenges that you mentioned in your presentation. But of course, research like yours is very important here to really spotlight what societal and regulatory needs we still have, especially because the goal of empowering and of empowering of persons with female reproductive organs is a really nice goal to follow, but it's very important that we get things right in this aspect. So thank you very much for your talk, and I'm very much looking forward to your comments or your suggestions.
Thank you very much, Aurelia. I don't know whether Marie-Hélène, you want to react, and I was also curious if I may just jump in about this, and I quote, complete regulatory failures, to which you alluded in your presentation and to which Aurelia also referred, to see what went wrong somehow in the UK and what perhaps could be learned in terms of lessons for future regulatory steps to be taken. Would you like to quickly react, Marie-Hélène,
Right,
before we shut?
Sure. I would love that. Thank you so much for bringing up these important issues and for this great comment, and also to a certain extent complementary. But I think this once again highlights the such important risks and how they should be taken into account when regulating these apps, how to find the right balance. Because the issue for me, and this is why I talk a lot about the potentials, that there are not so many alternatives, right, when it comes to fertility control. But for users to resort to these apps, they must feel secure. So I really like the fact that you mentioned again this chilling effect, right, and how to reconcile all of these discourses. And actually, even though in Switzerland we were not really facing such threats. So for instance, in the US, like you mentioned, Roe versus Wade, but there are still, I still hear of users that are refracting from using that. So you can really see how even developments outside Switzerland can have an impact. So I really liked all these practical thoughts also about data protection. And so regarding this interdependency also, I really like this interesting parallel you made, because we can really open some of these spots to this whole parenting realm, right? And the whole debate also around privacy issues linked to others, to children. And so to go back to really this interdependency, I think it made me also think about a recent Swiss case law from last year from the Swiss Federal Supreme Court, where a man had filed a complaint against his ex-partner for having had an abortion. after the 12-week limit. So in the end, of course, there was no conviction. Actually, the adoption was legal, and the court also said the ex-partner should not have a say in that, but it highlights the issue of, if you have access to the information, for instance, when tracking your partner's cycle, what can happen and the consequences, even in Switzerland. Regarding now the point also you mentioned in the question regarding the UK framework. So I think actually this is also a question I asked myself even when doing the slide, because I was also critical towards the fact that these fragmented frameworks are the essence of law, and actually they can apply to all kinds of products. And I also do think, I don't have the perfect solution. I also agree that to some extent fragmentation is needed. And we could also see in my presentation, I think that when it's not fragmented, so that means when links are made, there are also issues, right? So for instance, this interplay EU medical devices regulation and AI Act. And so just to briefly respond around the UK. So what's really interesting is that nothing really happened so much for such a statement to be made, but it was really stating and seeing that very similarly to the frameworks in the EU and in Switzerland, there was not so much accounting for the specificity of FemTech. So basically in the UK, there are very similar rules, not quite the same since Brexit, but regarding classification and qualification of medical devices, for instance, they are also derived from the EU rules. And so criticism was made again regarding all these classification and qualification points, but also, of course, regarding shortcomings in data protection, mostly. So I don't think there was one point in particular. I'm also not a UK law expert, but from what I was reading, it was really about not accounting for the specific users, the specific data, which when combined, right, also can lead to information about very sensitive issues. So not only fertility, but also religion, other preferences, and the like. So, and finally, maybe also reacting to the education point, I totally agree, and thank you for this comment, because I think it's important to also raise these points. And I also, I mean, in Switzerland, for instance, I feel like there is not so much education on this point, fertility awareness and so on. I feel like women need to take classes when they give birth to learn how everything works, which should maybe be, not be filled by these gaps. But at the same time, it's a tricky point because education is usually the thing that's mentioned when trying to avoid regulation, right? Oh, but we should just, we should just educate and having literate people, and so that's it. I want to also listen to Hannah's comments, so I will stop now. But thank you again so much for these very interesting insights. One last thing, maybe, and I also wanted to say thanks a lot for the very interesting practical suggestions regarding data protection in the field. I think they're very interesting.
Thank you very much. Yeah, let's turn to you, Anna from Kolfschooten, for your comments. And we also have, perhaps, you can also, all of you, have a look at the question which has been shared in the chat in terms of cybersecurity threats and the potential of blockchain technology, but we'll get to that after your own comment. Anna, you have the floor.
Thanks a lot. I'll share my screen with you. Can you now see it in full screen mode?
Yes, perfect.
Yeah, great. So yeah, thanks a lot for both your comments, Marie-Hélène, for your presentation. I think it's a very good overview of how the law works in this field. And for me, maybe I'm a bit more pessimistic, because for me, maybe the conclusion is that the law is not always the way to go to regulate these difficult issues. Maybe I'm also today in a particularly pessimistic mood because I do some volunteering work for a Dutch women's rights organization that looks at strategic litigation as a way to enhance women's rights. So yesterday I had a talk with one of my colleagues there, and they were thinking about taking on a case of a woman who was refused reimbursement of specific healthcare costs she had made because she had a certain a condition after giving birth, and she needed to have surgery for that, but the surgery was only covered by the Dutch health insurance if it was caused by a sports injury or by falling of the bike. That would be the case in the Netherlands, I guess, but not by pregnancy. And well, they were thinking about how to start a case against the Dutch body that decides which types of healthcare costs are to be covered by the basic insurance. And that also really made me think of this issue with the FemTech, because I think for me, it's not so much an issue of new technology or AI, but it's this bias, gender bias that we've had in medical research for a very long time. And in fact, that is, I think, the core of the problem. And I'm not sure if we can solve that with regulation at all, and certainly not with regulation alone. And I realized that's a bit of a pessimistic story, and maybe it's also more political than legal, but I wanted to explain this a bit further by showing you some recent newspaper articles. Half of it is in a newspaper, and the other ones are from the website of the University College London, who did recent research on this. So you see on the left top, women's pain is routinely underestimated and gender stereotypes are to blame. So this is exactly what this woman for the women's rights organization said. She said, I went to the doctor and I said, I have severe pain, so I really need the surgery, and it shouldn't matter whether I got that injury from my pregnancy or that it was caused in a different way. I'm in pain, so I should be entitled to medical care. And then also she noted that it was already very difficult to find a surgeon to help her because apparently there was no scientific research pointing out that this condition could cause loss of pain in women. So they didn't see a need to do surgery because the pain was not scientifically evidenced. And then you see that, of course, pain levels are, to a certain extent, they're subjective. But we also see in research that because of these stereotypes of women being on average of less physical strength than men, the stereotype that also the pain levels women experience is underestimated. I'll come back later to why this is important. Same thing with, so the left bottom, Nature article from last year. It's about the funding of research on women's health. And it says, women's health research has long been underfunded. This also has to do with stigmas. And in 2020, only, I think it's 3%, but there's something on my screen, so I don't see, 5% of global research and development funding was allocated to women's health research. So that also proves actually the point of this woman that we helped with the organization, that she said that the surgeon told her, yeah, but there's no scientific evidence that women experience pain because we don't even do this research specifically into women's health. Okay, so why this is important, I think, is related to if we use more and more AI algorithms in not just FemTech apps, but any kind of AI systems that are being used by women, is that when we develop a technological system, we make use of data sets, and we make use of data sets that are already existent. And these data sets are filled with information that we use in the real world. But this is the kind of information that we use in the real world that doesn't take into account 50% of our population, women's health. And that also means that most of these data sets are filled with medical data about men. So if that is already the reality, and then we put these kind of data sets into an algorithm, then also that will come out of the algorithm. So that means that women who go to a hospital already experience a lot of stigmas. There's already less medical information available about their health. And then when you take out the human, the female doctor, for example, in that and leave it to the AI, then the chance is only bigger that will reinforce certain biases. And we also see that here on the right side of the screen. ChatGPT thinks doctors are male, how AI mirrors society's gender bias. So if you ask, for example, ChatGPT to generate a picture for you of a, let's say, doctor performing surgery, then it is very likely that the doctor you get from your AI-generated image is a male doctor. And also because more and more newspapers and journals are using these AI-generated pictures, you will also see more in a newspaper that doctors are always portrayed as men, which will also feed into the stereotypes we already have. And also if we use, that's the bottom right news articles from also UCL. Also when we use certain AI tools on a broader scale, so here to screen for liver disease, then it is twice as likely to miss disease in woman as in man. And it also has to do with these historic data sets we use. So I think that is a additional problem that, of course, these FemTech apps are designed with the idea of empowering women. But how will we actually do that if we don't have the medical research available about those women? And isn't it then better to focus on that first? So we build these reliable data sets before we develop all kinds of tools that are trained on our historic stigmas. So that's just a question I want to pose. And maybe related to this is, I'll stop sharing my screen because then I can see you also. So maybe related to this is that also I recently asked my students, what would it help if we would acknowledge that these kind of apps are medical devices? So how would the law that we have right now solve the problems we have? Because the first question is, okay, is this a medical device? I would say yes, most of the companies are just trying to avoid these CE marking procedures. And they say, oh yeah, it's in our privacy policies in terms of use that just educate yourself, we are not a medical device. But even if you would pass that first stage, so it would qualify as a medical device, then it wouldn't actually solve these kind of problems. And I fear that is still the case if we look at the AI Act, which has an Article 10 that requires that you have a good data quality. And it also requires that you use a data set of high quality. But then a question remains is how do you get a data set of high quality if we apparently in medical science accept that we base our knowledge on the male population? So this is all very pessimistic, but I think it's also good to acknowledge the political side of things, because for me this is more political than legal, and in the end the law mimics society, and this is the society we live in right now. And another thing I would like to maybe just throw here on the table as another issue we could hopefully one day solve with each other is the really commercialization of women's bodies. So I don't think you mentioned this explicitly, but I think I've seen it in the paper you sent before, is that it's also really, these apps are really used to sell certain products to women. I once read somewhere that the woman who is trying to get pregnant is the woman or the person who's spending the most money in her life, because she's looking to buy all kinds of new things for, I don't know, everything from a baby room to new clothes to a lot of things. So that's a very good target if you want to sell your products. And that's also what often these apps do. They tell you like, oh, we see that you're about to get your period. Here's a discount code to buy some chocolate because you should treat yourself. And that is all marketed in a way of self-empowerment. But actually, yeah, we should also think about what we think of making women, yeah, so vulnerable to these kind of maybe even commercial exploitation. And maybe for that it's also interesting because the AI Act is not gonna do anything about that because they don't address these type of problems. But the EU did recently announce a Data Fairness Act, which is really focused on consumer protection. Because I think that if these companies present women as consumers, not as patients, then maybe it's also for legal protection a good idea to look in the same direction. Although I wouldn't agree with that like from a moral perspective, but I think from a legal perspective, there's maybe more you can do if you go in the same direction of commercial consumer protection. Yeah, thanks a lot. I'm curious about your thoughts about this as well.
Are we just allowed to jump in? Because just on Hannah's last point, like the thing you mentioned, there is like even this Target case about it, right? Like where I don't know if you remember, but in the US, where like a woman even kind of before having told her family and even like really being super aware that that the pregnancy was ongoing, etc. Target sending to that family, she was still living at home, like coupons for specific products, because actually, as you just say, not only are women like who are becoming mothers spending a lot of money, you're also very easily hooked onto one product line, right? Like it's the one time where you actually a clean slate on what products you're gonna buy. So it actually makes sense to target you because, you know, once you use the product from Nestle, that's what you're gonna be using afterwards, right? So that there is like a lot of kind of this commercial interest that you mentioned here is very important. Yes, I think Jacques, you just shared the article, right? And here kind of, you know, from like with data protection law, you already have some sort of means of countering some of these issues, but of course there's definitely more than can be done here.
Yes,
So
thank you.
Marie-Hélène, I'm just, a lot to react and hopefully also answers and reactions, which will hopefully make all of us perhaps less pessimistic for the
Right.
future. Obviously, there are concerns and challenges, but hopefully they can be addressed in the best possible way. Before turning to you, Marie-Hélène, for reaction, I'm sure, and to everyone also, we still have this question in the chat. I was also curious to see whether something could be gained in terms of consumer protection. So we know there's a patchwork of regulation. You mentioned consumer protection. I was wondering whether there is something to be done, specifically take into account, building on what you just said, Anna, in terms of taking into account the higher risk or kind of fragility, so to say, of women as consumers in certain circumstances, and potentially to use consumer protection law, but adapted in a way, if that is feasible at all, in order to take into account these specific circumstances. And using, and now turning to you, Marie-Hélène, this kind of patchwork of regulation framework in the best possible way by taking advantage of all the pros, ideally, of each regulatory set to maximize the protection if need be, and if feasible at all, depending on the circumstances. But I just wanted to also come back to what you said in terms of consumer protection, what role that might play in this discussion that we're having today. But to you, Marie-Hélène.
Thank you so much. So I will respond in order. So first of all, thank you so much, Hannah, for this great comment and highlighting. I think this pessimistic side is also important. And while I think we should also try and be optimistic about the potential and also be realistic about the fact that, as mentioned, there are not so many great alternatives to them. I think the risks are still really huge, and to a certain extent, I'm not sure how we can really mitigate some of these efficiently. I also think it's important that you mentioned this political aspect, because I think especially this topic, everything around AI is highly political. The case of Switzerland is very interesting as well, because there is a choice of not intervening too much because we want to promote innovation and not impose too much burden on manufacturers and all that. So everything, all this is very political. All things related to women's bodies as well, as we see with the developments in the US. And I thank you for these great examples of the risks of advertising, because I actually had also private conversations, and I think some people might underestimate even just the impact of marketing, right? If this is provided, in the data, in the contract with the company. So I think this is very important to mention, that even when it's, so to say, legal, it might be very problematic. And so for your practical example, also, I'm very grateful. And I think it really makes me think of this paradox when talking about women's health gap in research, because on the one hand, we have seen, for instance, studies around menstruation and vaccine that was done with data from fertility tracking apps. So you can see there is a potential here to help addressing this gap, but at the same time, all of these technologies, especially combined with AI, can contribute to worsening the biases you mentioned and the gaps. So I also don't know exactly how to balance the two and how to try to take advantage of these technologies the best way. And especially because this is a very specific crowd, we are talking about these users of these apps. And for those that are not in the averages, all of this can be very, very tricky. So I don't have an ideal solution on how to also avoid all the stigmas and all these specific issues linked to that. And I think it's very interesting also that you talked about, when qualifying, for instance, as a high-risk system under the EU AI Act, some of the new requirements that could apply. So, for instance, having good data quality. I think it's very interesting, and it will be interesting to see how this concretely can be implemented. I salute your concerns also. What does it mean? How can we have a data set of high quality? I'm also not completely sure here, but I think it's still a good attempt to try to protect users, even though, as I mentioned, it will be easy for companies to say, oh, but we're, in the case of fertility tracking apps, we're marketing something for conception only. So, it actually escapes all of these additional protections. And so I think this nicely goes back to Jacques' comment around consumer protection law. Maybe the answer could be in that, and so sort of taking away the focus on medical device law, for instance, among others, and so really focusing more about the consumer. I am not sure exactly how this could take shape, but I think it could be an important start and thing to think about. But I don't have specific recommendations yet. I also agree. I think data protection is really one key aspect in all that. It's tackled notably by the new AI Act, but it will also not apply to all Swiss companies. So there is room for improvement, and at the same time, I think we have to remain realistic that independent of the laws, there will be the concrete application and the gaps and the enforcement, and so yeah, it's a tricky point. But thank you again.
Perhaps we can turn. There are two questions in the chat. If we take the one which has just been put about, I guess everyone can read, but can we ensure that FemTech apps protect women's sensitive health data, especially in countries where women's rights are limited? And can these apps play a stronger role in raising awareness for those countries compared to other programs or platforms? Any thoughts?
Right. Well, I'll say something, but then of course, Hannah and Aurelia, you're welcome to add on this. So I think it is very difficult, even with the best standards and the most comprehensive laws, to adequately ensure that these women's sensitive data will not be misused in any point, especially because there can always be cybersecurity risks and leaks. So I think here today there was the news, or yesterday, that the company 23andMe, so it's a company selling genetic tests, filed for bankruptcy in the US. And so now there's a big question mark around the future of all the genetic data that was of all the DNA tests that were done for the people that bought the test from the company. And so for me, it really highlighted the risk of any risk around the simple handling of the data, right? What if the private company that that has all this data has an issue, and even a legal one? So I think that's the tricky issue, and this is why, in a sense, it's difficult not to be pessimistic around this. At the same time, I think that we can do a lot to strengthen data protection rules, but also practices around these, especially in Switzerland, in the EU. There is also a lot that's being done for that. And I think, but if we take a look at, for instance, I think the US, at least certain states, is a very good example of I think settings where I don't know how we're going to move forward, because we have heard, of cases where investigations could be made with data from this FemTech. After the overturning of Roe versus Wade, there was a lot of press and articles saying, well, you should not use these apps. So I think, especially in this context where women's rights are in danger, so to say, I am not sure we can promote the use of these, but we will. I guess we will also see how all of that will evolve, because I think one other point I didn't mention is that there is a huge trend also around governments to push, for more babies and awareness around fertility. So maybe governance will realize that this could be an asset, but only if adequately protected. So maybe this could advance things a bit.
Maybe if I can add to that last point, I think it's not so much the apps that are the problem, but the business model behind it. So it could actually be a solution if there is a government or a nonprofit who would develop an app that does not have that type of business model where you essentially make the woman the product. Also, to come back to your question about the consumer protection, so there's this quite old directive in the EU, the Unfair Consumer Practice Directive, if I say it correctly. And And then it's not so much meant for online, which is also why the EU is thinking about issuing a new one. But it's really, yeah, these basic rules of if you're selling a product, then you have to be clear about, I don't know, any hidden intentions you have, any side effects that could occur. And I think that's also the same issue here, that if you have, so in this new digital, let's say, consumer directive, they're thinking about regulating dark patterns. So the idea with dark patterns is that you, in the way you shape the technology, you're influencing the behavior of the user. So an example is that, I don't know if any of you have ever played Candy Crush or some kind of game, but then you get like all the time these pop-ups that say, you have won a prize, or if you don't click on this within 10 seconds, then your deal expires, these kind of things. So you're manipulating the user into doing something, so changing behavior. And this would then be prohibited under this new directive. So that could already, like from a legal perspective, that could be an idea with at least the advertisement side of things. But I think it could also really help if you, because they always say, if you don't pay, then you are the product. So I don't know if you can convince people using these apps to maybe, get like pay a small membership fee, and then you know that the data is always stored locally on your phone, or because it's, I think, just reality that app developers need to make money. So they can either do that by selling your data to whoever wants to buy it, or they can get the money from you subscribing to a safe app. So I think there's still, maybe from an NGO, maybe from the government, maybe from just a company that wants to, use a different business model. I think there's also maybe a market in that, especially in the US, where women are already more aware of the risks, and maybe the risks are also much bigger there. But then in the end, I'm just a lawyer, so I don't know what would be a good business model. But I'm sure that someone would like to take this up if it becomes really clear what happens to all this data.
Maybe just to jump in, Hannah, here on this point. So I mean, so I agree with you, right? Like, so the business models behind it is clearly what creates a lot of these problems. Maybe I'm a bit more pessimistic with respect to whether we can change these business models so easily, even with the regulatory patchwork we see in the EU on different kind of practices, like, like all the acts that came out, or regulations at the moment. Maybe there is, though, kind of something to say on like the creation of these more trustworthy data spaces, the use of certification, and these more visual elements to gear consumers towards products that are more quote unquote trustworthy. And in here, the things you mentioned before as well, right, with respect to depending right on the tool that you're looking at, because data quality might not even always be, like, there might not even always be a lot of ML behind some of those apps. Like, some of those might just be literally using the average day of, I don't know, whatever the cycle is, and using that, right? So I don't think all of this will be related to AI necessarily. But kind of ways of thinking about ways of creating self-certified schemes that, or as we see also within the privacy realm, like labels that give an easier input to the user, or educate the user more visually about possible kind of trade-offs that they're doing when deciding on a specific app. Maybe that helps. Or goes into the direction that you kind of mentioned with, like, like more an NGO or government taking over the creation of a specific technology, which might work, but is usually hasn't really been shown to kind of been so effective, at least not nowadays, because things move so quickly. But I'm curious what Marie-Hélène thinks about this.
Yeah, thank you so much. I agree with you. I also thought a lot about this. How can we avoid this business model of selling data? But I also think just saying, well, we could have government-funded solutions is a bit optimistic, right? And I also think, well, we already sell our data everywhere. I mean, it is the business model of all of these large companies. So this would also be a huge shift from this perspective. But I really like this idea of you know, trying to work on the data frameworks and how we can try to at least make it better, because I am really convinced that to some extent users will continue resorting to these apps. So there should still be some work on trying to improve that. And I think especially because of what you mentioned, they're not aware of all the trade-offs. So they will keep using them, at least as long as they don't really realize what all the risks are, right? Thank you.
Perhaps if I may just again come back to questions that are on the chat. One is about, and that I was briefly touched upon, about cybersecurity and whether potentially blockchain might be of relevance in order to increase the level of protection of data. That was one. And the other one is about the possibility, and perhaps also in terms of crucial, be in a position to create and market those apps. And the challenge is, if we assume this is left to the market, how can companies manage those risks? And I speak under the control of Adam Strobejko, who has asked the question, and please do feel free to intervene, Adam, in terms of managing these challenges. And to me, and listening to all of the points which have just been made, I'm just kind of struggling between like developing and thinking about dedicated tools and regulatory solutions which would be tailored to what we're talking about here, and trying to see whether we can somehow use general instruments, be they consumer protection and also labeling, and trying to see certification, self-certification, which are tools which obviously, as we all know, can have various applications, various areas, and see whether we can somehow find ways to use those general tools in a way which is relevant in the specific context, or whether, to the contrary, we would need to develop innovative solutions given the specific challenges that arise. I was just looking on the internet about gender-related consumer protection, and I'm just sharing on the chat. Of course, this is not relevant at all for the discussion that we're having now, but to see, can we learn from other areas of regulatory measures or ideas which have been put on the table to see to what extent that might be of help in trying to address some of the challenges that we're facing here. But that's just like one thought, but perhaps to first blockchain and then the kind of way how companies can somehow manage those challenges. But blockchain, perhaps, Marie-Hélène or Aurelia or Anna, any thoughts?
Yeah, so I'll start, but it will be very brief because I must say I am not a blockchain expert. But thank you for it's a very interesting perspective. I think to some extent, as you mentioned, if there is more security, it could be a good avenue to explore. Even though I mean, as mentioned, I'm not an expert. So, but when I think about blockchain, I also think about the risk of the anonymity, right? So I think there's also potentially a topic to be addressed here, right? Because I think one of the important, I mean, not solutions, but for me, an important aspect of all of this handling of data, for instance, is also surrounding transparency. What happens with my data? But I will stop here because, as mentioned, my knowledge of this technology is limited. I don't know if others in the commentators or audience have something to say around this technology.
No, I just wanted to say, I have the feeling, but I'm not sure, but from my colleagues working on blockchain, that there's already new avenues to protect data better than blockchain. So what I was thinking more is about, because this is essentially about who accesses your data without your knowledge and consent. And I think that the real problem is more that you do consent to these apps sharing your data with all kind of third parties. So of course, cybersecurity is also a risk that people break in and can steal your data. But I think, yeah, the first risk to tackle is, yeah, more essential here, that you actually consent. Like, these apps are not breaching the law or anything, because you consent with your data being shared. So I think that's our first worry. And then, of course, also thorough protection of cybersecurity is also very important, which also can be solved by using apps that do not use a cloud service, but save on your own device, which is how many fitness apps now operate, that are privacy proof, but then you do need to pay to the company in order for them to, still have a profit.
And to the ways for companies to manage, and perhaps Adam, do you want to react and perhaps take the floor?
Yes, thank you very much. No, it's a very interesting discussion, because if it was a simple case of medical device, it would be very regulated, right? But since it comes in form of an application, and there is no clinical trials, no pre-market authorization, and no post-launch monitoring, it was a very interesting. It's very interesting for me to think about the legal instruments applicable. But since it's also at this intersection, there are just so many of these instruments that I was wondering, if you're probably if you're a big company, you have a compliance department. But if you're a smaller company, how do you deal with these risks, and how do you navigate, and what kind of legal frameworks you think can be useful for that purpose? Thanks, Marie-Hélène.
Thank you so much, Adam. Great question. I think for me, it, first of all, makes me think of the general issue of compliance, because as you point out, it's becoming very difficult for small or even medium companies to really follow up on all this. And I was actually talking to a digital consultant who was telling me, actually, in Switzerland, even, all of the companies are very worried about the EU AI Act. Everybody's trying to escape the high-risk system qualification, and especially the small companies are really worried, or how are we going to address that? So I think especially the different layers, so medical devices, data protection, all that, they don't make it easier. Even though to a certain extent they can be handled together. And I think, just to give you an example, for me, it was a funny one in this court case, because actually the court case concerns the same application, the fertility tracking application. And first they just try to, not be qualified as a medical device at all. And then they were not happy with the classification, and they also actually tried to bring up the argument that so many other apps are not being compliant in Switzerland and even in Germany. So I think for me this was a very funny example of, of course this did not work at all as an argument, as a legal argument. But I think it does show, and also the quotes from Swissmedic, that there is probably a lot to do in terms of how all of this compliance is adequately made. And I think this explains the restraint from the Swiss authorities when it comes to regulating AI. And they also mentioned the cost. They say, well, if we would apply something similar to the EU AI Act, or take all of the provisions in Switzerland as well, that would be a huge cost, also for a lot of huge burden on companies, even though they recognize that it might apply to some of them in any case. But then there are also recognition issues with other jurisdictions. So I'm not. I think what I can say on that is that it is tricky. It is difficult. I don't know how they're going to navigate that. I guess there is a need for a lot of experts in the field of compliance. But I'm happy to hear if there are other perspectives or insights here. Thank you so much.
Any final thoughts? Because we're just reaching the kind of planned time limit that we had for this session, and wanted to give to our speaker and to our commentators perhaps an opportunity for sharing their last comments. Yes, Hannah.
Sorry. Adam, I was also thinking, reading your comment, that also the app stores can play a bigger role than they do right now. Because in the end, it's also about translating legal requirements into technical ones, which is, for the average lawyers, that's also really difficult to do because they don't speak the same language, so to say. So I think also app stores that allow whether certain apps are marketed in their stores can also be quite good mediators in having more clear guidelines about when, for example, you are processing medical data or what kind of requirements you need to meet. But then the question is still like, do they have an incentive to do so? Because legally, I think they're not even considered intermediaries, so you cannot hold them liable. But it could be a good practical solution.
Thank you, Hannah, for this. Actually, I read this from you the other day, and thanks a lot for bringing it up. Yeah, a very interesting path as well.
Thank you very much. Any final thoughts, Aurelia, perhaps?
Thank you very much. Sorry, I froze a bit, so I didn't hear the last point that you guys made. But thank you very much for this interesting discussion, and Marie-Hélène for the interesting research that you're pushing along. Final thoughts. I don't know. I think there are different, like, I mean, as you said before, and I think as we said and made also clear during this discussion, right? There are lots of moving pieces. Like, I mean, this is a complex field. I understand Hannah's pessimism with respect to lots of aspects, but I think we do have, like, looking at the regulatory landscape, we have different tooling and different ways of addressing some of those challenges. But it's also about actually going about them. And I think kind of this lack of enforcement that we see in many legislations already, and not making it right now easier because of multiple authorities and governance bodies needing to kind of play well together, right? I think that's for sure a challenge that we still can be much better at addressing. But at the same time, I also think there is a way kind of these are, we do have some tooling to kind of start and try to address these things. And then maybe the very last point, and kind of to wrap up also the points that Marie-Hélène made, right? Like, you ended with this idea of need for education. And from what I hear, it's not just the users, but Hannah is also making a point to say, yeah, but even the app stores, right? Even the people controlling the gate towards the end user needs some sort of education. The app developer needs some sort of education. So I think there's kind of still a lot to do in this spectrum of providing and generating that awareness that we can do. And yeah, I do believe that these different aspects and the different ideas that have come up with respect to labeling, certification, trustworthy data spaces, etc., should play a role. And I mean, we'll see, right, where this develops. But I think we need to start integrating these different elements better into those discussions. But yeah, thank you very much, Marie-Hélène and Hannah and everyone at the Digital Law Center for kickstarting also these discussions here. So I think this was very interesting. At least to me, I've learned a lot. So thanks for opening my eyes to this spectrum.
Thanks very much, Marie-Hélène. Do you want to say a few final words, conclusion.
I think I've spoken quite a lot already, so I will not take up too much more additional of your time. But I just wanted to say thank you so much for listening to me and for engaging with all the thoughts. And I really appreciated all of the comments, the questions, the discussion. I think this topic really is so paradoxical, but also opens up to many adjacent fascinating topics. So thanks again.
So next time we meet, there will be an app which will meet all the criteria and expectations, and
exactly
exploring that and testing it. But I think I was also very interested and intrigued by thinking about the role of the app stores as kind of gatekeepers, so app keepers, and trying to see what kind of role and potentially obligation they may have going way beyond what they're doing today. But again, this is kind of a transversal issue. You can apply that for addictions, also kind of whatever a concern that may arise. But that's certainly a different topic or a broader topic. So I think we should wrap up and congratulate and thank you all very much for the very stimulating discussion. Also thanking the team at the Digital Law Center, specifically Amjud, Joseph, who is with us today. Many thanks for putting that together. So very much looking forward to the next opportunity to continuing the discussion, and looking forward to catching up soon in person, hopefully, or at least virtually. And wishing you all a very good evening, and perhaps to Marie-Hélène, Hannah, and Aurelia, we can stay a few minutes online if you have a few minutes to spare. Thank you very much. Good night, everyone. Bye-bye.